that is scheduled for July 18th, 2011. I'll call the meeting to order, and I'll ask my fellow board members if they've had a chance to look at the agenda for today and if they approve of same.
Motion to approve.
We have a motion to approve. Second by Mr. Hudgens. Any other discussion? All in favor say aye.
Aye.
All opposed, no. Motion carries unanimously. Has everyone received a copy of the minutes of our meeting on June 20th, 2011, and have had a chance to review same? Are there any comments or corrections to the minutes? Do you have anything, Scott?
Just a spelling thing right there. I think it's correct.
Yeah. You want to?
There's a minor spelling issue, or name misspelled. I think it was Chip Craig. Page 3 of 4, fifth paragraph down, second sentence. That's just minor spelling, but other than that, I would move to approve with that correction.
Okay, we have a motion to approve with that modification. Do we have a second?
Second.
Mr. Hudgens seconds. Any further discussion? Okay, all in favor signify by saying aye.
Aye.
All opposed, no. Motion carries unanimously. The next item on the agenda for this morning is a public hearing regarding a zoning map amendment. Ms. Nancy Bonham has applied to rezone tax lot pin number 9623-96-9198, also known as 50 Bonham Road. It is currently zoned residential district R2, and she would like to change that to residential district R3. Debbie, would you, either you or Jillian, please give us a staff report?
Yes, sir. This property is 132.34 acres, and it is being requested to be rezoned from R2 to R3. The property is located near Pennsylvania Road and currently is a farm. The surrounding area is characterized by large tracts and single-family residential development, which is zoned R1 and R2. The requested zoning would not be consistent with the Buncombe County Land Use Plan update, as the update indicates that R3 is suitable for higher density uses and mobile homes. The zoning would be detrimental to the adjacent neighbors and surrounding community, as it may lead to the encroachment of property zoned R3, which would allow mobile homes, mobile home parks, and multifamily development. The Planning Department recommends denial of the request.
Okay, thank you. Is Ms. Bonham here, or is there anyone here representing her?
Mr. Chairman, my name is Andrew Colvin. I'm an attorney with Nexon Pruitt up here on behalf of the Farm.
Okay, if you would, please come forward and again restate your name and where you're from and who you represent into the microphone, please.
Sure.
And if you don't mind, tell us a little bit about this application.
Sure. Thank you. Once again, my name is Andrew Colvin. I'm an attorney with Nexon Pruitt Law Firm, and I'm here on behalf of Ms. Bonham. I want to thank Debbie and staff for the staff report, and thank the Commission for hearing this rezoning today. I was actually sitting in your position not too long ago. I was a planning commissioner for the town of Bluffton near Hilton Head, South Carolina, just until a few months ago, and I just moved to Greenville. So I have a unique appreciation for your volunteer time and what you do. I'd like to address and alleviate some of the concerns that are in the staff report today. I think you'll have a better understanding and appreciation as to why my client has requested the rezoning. First, if you go through your use table, you'll see that there's not a whole lot of difference between R2 and R3. The staff report focuses on a few of those which are typically negative, impacting the surrounding properties, namely mobile homes and mobile home parks. As Debbie mentioned, this is a farm. There's 2 mobile homes on the property already. But my client, I can assure you, has no intention of putting any more mobile homes or having a mobile home park or having a travel trailer park on this property. There are other uses permitted in R3, which for whatever reason are not permitted in R2, which I think most people would consider to be less detrimental to the property. The ones that are permitted by right would include a bed and breakfast inn, rooming houses and vacation rentals, and as far as by right, give me just a second. Clubs and lodges, those are the three permitted by right. As a conditional use, you could have wireless communication towers, nursing homes and assisted living facilities, kennels, and landing strips. Obviously, a conditional use would mean they'd still have to go by the Board of Adjustments. Now, mobile homes would be permitted, and mobile home parks would be a conditional right. As I've stated, my client has zero intention of putting those on the property. Is that the main concern that we're having to address today? Is that the concern of the commission or of the people here? Is it the mobile home parks?
Well, when you look at a rezoning, any allowed use has to be considered for the property.
Right.
Not just what the current owner
Sure.
is wishing to do, but what any future owner might be able to do.
Well, the reason that I'm asking is that for this rezoning to go through, my client would be willing to put deed restrictions on the property that would not allow any mobile home parks, no more than 2 mobile homes, and no travel trailer parks. From what I understand, that seems to be the key opposition here, and hopefully we can alleviate that with this. Alleviate that concern with this. If there are other concerns, then I'd like to address those. And the last thing we want today is a recommendation of denial. So we want to get this approved, and hopefully that'll be enough to do that. Also want to address a couple of the things in the staff report that I think are a little bit misleading, but we can address those here. But they make references to multifamily and higher density units. Multifamily is the same in R2 as it is R3. They're both permitted by right. If you look at your use table, if we were here for multifamily today, we wouldn't be we never would have requested the rezoning because you don't need to. The higher density units, if you take away the mobile home parks, if you take away the travel trailer parks, it's the same lot dimension and building requirements. You're going to have the same setback lines. So if we take those away, there's not going to be any higher density on this property. So basically, it boils down to this. My client has considered a certain use on her property for a while. All of a sudden, a couple of years ago, zoning is imposed on the property, which forbids it. For whatever reason, it's allowed in R3, but not R2. And by approving this zoning request, you're basically allowing this property to have, by right, bed and breakfast inns, clubs and lodges, rooming houses and vacation rentals, and upon application for conditional use, other uses such as nursing homes and assisted living facilities, kennels, landing strips, and telecommunications towers. That's it. You know, as I stated, we'll put the restrictions on the property. No more mobile homes, no mobile home parks, no travel trailer parks, no additional density that you couldn't get already under R2. I don't know that you could say that as a 132-acre site, this is a bad site for any of those uses, except maybe a landing strip. Yeah, I don't think you'd want to put that on there, but that's it. So if you have concerns still after we address this, please address those with me. I want to answer the questions that you may have. I want to see if I can address any concerns of the people here today. You know, again, I hope that the idea to put the restrictions on the property will alleviate that. We didn't see the staff report until Friday, but came up with this plan over the weekend in response to it, which I hope will do that. But if we need more time, then you know, I'd ask that you give that to us as well so that we can try to come up with something that will work.
Okay. Does anyone have any questions of the applicant's representative at the moment?
Well, what You referred to historical use. Can you be specific? I mean, what is it that property's been used for in the past and is now zoned so that it can't be used?
Well, it's a farm, and it's not that it's zoned that it can't be used. I mean, the mobile homes that are on there wouldn't be allowed anymore, but they're grandfathered in. They
Right.
you know, were just there. But it's a farm. It's been a farm, and we're not asking for a rezoning to continue to be a farm. You know, it's for a new use that's permitted in R3, but not R2.
We have a communication from a surrounding property owner that indicates that you intend on using it for a cell tower or for a communications tower.
I can say that the site has been identified as a very good site for a cell tower, given that it's a large site, 132 acres. It's it's not an area that's going to attract children. It is, there's already a power line easement that goes through it, so there's already utilities on the property. You can see that from the aerial, and because it's kind of on a ridge, it's not going to be something that just peers up over on top of a mountain. There's a higher elevation above it. Cell towers have to go somewhere, and there's a need for it. There's a demand for it, I know that people don't tend to like them near them, but they do have to go somewhere, and so that is one possible use for the property.
Regardless of the future use, I have a concern about spot zoning. Mr. Euler, would this be considered spot zoning since there's no other R3 in the vicinity?
I don't know if you could go so far as to say it's spot zoning. I would say that you were injecting a higher density of use into an area that it's kind of like you're planting the seed of a very higher density use that's not currently allowed and is not currently, there's nothing like it in the surrounding neighborhood, shall we say, and you're really dealing with big, large tracts. So you would be then you would be allowing these more intensive uses in this area.
The person who wrote, the adjacent property owner that wrote the letter made a suggestion that that maybe you subdivide out where you want to put your tower and have that zoned as R3. I mean, is that...
If you reduce the size of it, then we get more into
we kind of
potential
more into
for
the spot zoning?
Yes.
Yeah. I mean, the size of the tract by itself
I don't
perhaps
think
lends
that
itself.
The size of the tract in and of its, I think that's what keeps it from being spot zoning. I do agree
That's correct.
that the more you try to reduce it, I think in order to avoid spot zoning, I think that you have to look at what's around the property, what's going on around the property. That's usually the best indicator as to what the land use plan is intended.
Kurt, how about the suggestion that he made regarding deed restrictions being replaced on the property that would prevent its use as a mobile home park, et cetera? What's your opinion of that?
Well, I would have some concerns that if the Bonhams maintain ownership, because they could very easily, after they get the zoning that they want.
Could I just offer a suggestion that, if we put the restrictions on the property, that perhaps the county would have to agree to take them off, or?
As I said, I think that you're a legislative body and you're not really, you're looking at more of the overall picture. You're not looking specifically with this property. So even with the deed restrictions, I think that you need to look at I don't think that should be dispositive of your decision. And as I said, deed restrictions can be removed, so it's nothing permanent.
If I can
Yes, go
interject
ahead.
again, the other option, if that's not acceptable, would be to somehow request that a particular use be permitted in R2, which is not currently. Which is preferred? I mean, if it's either, I would think the deed restriction will effectively accomplish, I think, what you want. It may, in theory, cause an issue with an attorney or a planner, but it'll be effective. The perhaps the more clear way is to go through, changing the making certain use permitted in R2, but that's a whole nother process, and this, of course, costs my client money and everything to go through all this, and time as well. So that it's not certainly not what we prefer, but we want to we want to make this work and work with the people and alleviate concerns as much as we can. So.
Okay. Does anyone else have any questions of the applicant? Okay, hearing none, thank you very much, and I think we'll move into the public comment period regarding this particular subject. And I'll open it up by saying, as it's already been addressed here, we received a letter from a David Klaber, I believe it is. That's from Pittsburgh, Pennsylvania, and I think, and he lives in the Walnut Cove area. I think what I'm going to do, I think I'm going to go ahead and read it as part of the record. I'll read it quickly, so it'll be part of the record. And then following that, we'll take comments from anyone that wants to comment either for or against on this subject. The letter was written on July 15th, 2011. It was sent to our Assistant County Manager, John Creighton, via fax. And it says, "Dear Mr. Creighton, I am an adjoining landowner to the property referenced above, owning undeveloped property on Deep Creek Trail in Walnut Cove, lot number 46. I just received your notice of the Buncombe County Planning Board meeting scheduled for Monday, July 18th at 9:30 a.m. Since my current residence is in Pittsburgh, Pennsylvania, I am unable to attend the meeting. Please refer this letter to the Planning Board since I am unable to attend. I understand that Nancy Bonham wishes to have the property in question rezoned in order to erect a cell phone tower. While I would prefer that such a tower not be erected in a residential community, presumably it would be acceptable if placed in the proper location, if not too tall and if adequately disguised. However, I have great concern that a general rezoning of Ms. Bonham's parcel would jeopardize this wonderful neighborhood which adjoins the parcel in question. If rezoned R3, in the future, the property might be sold to someone who does not wish to protect the property, as I am sure Ms. Bonham does, and who might use it for industrial use or for a trailer park or some other R3 permitted use that would destroy the current bucolic, rural, forested setting that is in the admiration of the persons across this country, as well as residents of the Asheville area and Walnut Cove. Moreover, it would clearly have an adverse effect on property values in Walnut Cove. May I suggest this? Could not the bottom farm parcel be subdivided or permitted to build an appropriate cell phone tower on a very small segment of the parcel only, keeping the remainder of the property zoned R2? This approach would protect the neighborhood and the environment and permit the desired limited use without exposing the entire parcel to unfortunate misuse in the future. I would prefer the parcel in question remain R2, but this approach would be a reasonable compromise. Please advise, very truly yours, David Klebler." Now, having read that, would anyone like to come up and comment? If you would, please come up and state your name and where you live, please. And you'll have 3 minutes.
Okay. My name is Jim Peterson, and I live at Julia, my wife and I live at 12 Creek Hollow Court in Arden, which is in the Walnut Cove community. And I appreciate the opportunity to speak and address my concerns about the proposed rezoning. I wasn't aware of that letter that you read, and I agree with most of what the writer had to say, except I don't agree that carving out a section for a cell phone tower would be a good idea. In terms of background, the area we're discussing is residential with a few small farms and vacant wooded land. The Blue Ridge Parkway and the Pisgah National Forest are in the background. I mean, it's a beautiful residential area. That's why we chose to live there. Rezoning the Bonham property to R3 would not be a good thing. It'd substantially impact the area and our community. I'm very concerned that a rezone could have an impact with increased traffic, noise, light pollution, road use, sewer and water requirements, plus the detrimental effects of a cell phone tower. This wouldn't be compatible with the immediate area and would negatively impact us and our community in an economic sense, property values, as well as the quality of life in the area. A cell phone tower would be unsightly and objectionable. It wouldn't fit in with the character of the landscape and the residences. If you go to the Gorilla Car Wash on Airport Road, you can see what a cell phone tower jungle looks like. It's not pretty. Other permitted uses under R3 would be as bad or worse than a cell phone tower. R3 isn't consistent with the current and intended land use under R1 and R2. Isn't that why we have zoning? The closest R3 property is over 4,000 feet away. Now, I'm not an attorney, and I don't know what spot zoning is, but it's dropping a chunk of R3 into a middle of R1 and R2 with nothing contiguous that's R3. I don't think that's the intended land use plan. So anyway, I agree with the staff. I think they did a good analysis. And I'd urge you to not allow a rezoning because it would have a substantial negative impact on the overall area, our community, and us personally. Thank you. And I think there's other folks that might like to speak from our area, too.
Okay, thank you very much. Anyone else? Again, please state your name and where you're from.
My name is Jim Matthews. I'm a resident of 333 Stone Ledge Trail in Arden with my wife, Deborah. And Mr. Peterson is a neighbor of ours, and I think he expressed well the views of many of the people sitting in the room. And so rather than reiterate those, I would say I agree with the points that he made. I think any of us could sort of pile on and add our concerns to those, which are very significant. And so with respect to the committee's and the commission's review of the matter, we agree very strongly with their conclusions. And the one thing that I would add is that it feels to me like a very slippery slope to go down a path that says we will take a current owner's intent in terms of either current permitted uses or rezoning on a broader scale that permits the future value of the land and potential future owners to make determinations as to the attractiveness of this particular property based on alternative land uses. So I would just suggest that it gives us as nearby owners very, very little comfort to know that either the current intent of an existing owner or that there's some very narrow carve-out that runs in opposition to what the current zoning restrictions are and potentially requires a spot rezoning to allow something of this nature. And I thank the Commission for taking the time to examine this issue and for our ability to appear here before you.
Thank you very much. Good morning.
Thank you all for taking time to hear our objections. My name is Elaine McGuire. My husband Jerry and I live in Walnut Cove at 247 Secluded Hills Lane. We moved to the beautiful Blue Ridge Mountains and are full-time residents. We came here because of the aesthetics of the place. It's the most beautiful area we've ever lived in, and we intend to live here until we leave planet Earth. Having said that, we don't want to leave planet Earth too soon because we're living too close to a cell phone tower. The electromagnetic frequencies emitted by a cell phone tower are a real cause for concern, and contrary to the cell phone industry's positions on this matter, there is substantial evidence, many studies done that indicate that there is a huge impact on human health. I should think the Bonham family would also be concerned because of their proximity, potentially, to a cell phone tower. There have been many studies done. There's a lot of information on the internet. The impact on animal health, the impact on human health. The link to cancer is very real. It also impacts the immune system and the brain function. All kinds of evidence there as well. And we have reason to not want, other than the aesthetics, to have a proximity to a cell phone tower. Granted, they have to be somewhere, but they should not be in the middle of a residential area where many people, all of our neighbors, have moved here from other areas and love it, are here for the Cliffs wellness programs, and to have to concern ourselves with the EMFs, and to have there are all kinds of ways of diagnosing. You need to have an RF radio frequency gas meter to determine the microwave intensity, and there are all kinds of hot spots. And it really is no safe range. 400 feet is not even close to a safe range, and you can go beyond 1,000 and still have a health impact. So more than the aesthetics, the health concerns are part of our objection. Thank you for hearing us.
Thank you very much.
Ms. McGuire, let me ask you a quick question. You don't own a cell phone?
I do.
I just wanted to clarify that.
I do, and I have very bad reception where I live, and I'm okay with that because I don't think people should use cell phone extensively. I think that's also a concern. We all use it for convenience, but I think that we all should be aware of the fact that that does have some impact on our health.
I have 3 near my house, and so, I mean...
Three cell phone towers?
We live in open use, so, I mean, the fact is we have 3 towers near us, and so, I mean, I understand your concern. I do. I just wanted to clarify that.
Thank you very much.
Thank you.
Thank you. Next.
Good morning. My name is Mike Gosling. My wife Sharon and I live in Walnut Cove, but we live on Deep Creek Trail. And we also, according to the pictures that you have, we are the last residential property that was so far has been built on Deep Creek Trail. So I'm right across from the property. Cows are there. They engage with our dogs every day that we're here in town. We live in Bethlehem, Pennsylvania now. This is our retirement home. When we looked around where we would retire anywhere in the country, we chose this property to be in Asheville and the Cliffs in particular. And where we tormented ourselves with respect to the Walnut Cove property was it's a spectacular, view, but what was going to happen next door, and that was a major consideration for us. When we looked through it and asked some questions, the designation of R2 versus R3, I didn't begin to understand it. But what it did limit is people may build homes there someday, but you couldn't do mobile homes and you couldn't do cell towers. The reality of it is R2 versus R3, as the attorney rightfully said, it sort of subtly only kept certain things out from there. And my wife and I sort of accepted the fact that somebody may develop there adjacent, that it would be good value for them because there are multi-million-dollar homes that were being built adjacent to that, and we could live with that because it would just, it would help their property value immensely, given the fact that there are 3 houses going up right now on Deep Creek Trail, and probably the combined development costs in Deep Creek, all with views here, is probably north of $8 to $10 million in terms of intrinsic value. So any home that would be built next door would have value, and the property value has been enhanced. What we took our bet on is that you wouldn't move from R2 to R3 and then put even any risk of things like mobile homes, and I consider a cell tower equally as offensive as the mobile home. Thank you.
Thanks, sir. Anyone else? Good morning.
Good morning. My name is Jim Gaunt. I live at 359 Stone Ledge Trail. in Walnut Cove with my wife, Patricia. I want to make 3 points that have been generally talked about. Number one is the issue of the totality of this decision. It's beyond the bottom farm. 2 is the issue of intent, which the attorney spoke to. The intent versus the R3 requirements. You can have all the intent in the world, but the law is the law and the code is the code. So once R3 is allowed, no intent could overcome what the code says. So that concerns me. And 3 is the issue is not July 18th, the issue is tomorrow. The tomorrows of the world. That's why these residents are here. They're concerned about what they and their families would enjoy in the future. So I appreciate you considering that when you consider the totality of the issue. Thank you very much.
Thank you. Anyone else?
Good morning. Thank you. My name is Jeff Henshaw. I'm here representing the High Vista Homeowners Association, and we are a neighborhood that many of the lots are within 1,000 feet, and so we did receive notices, and actually a number of the lots are actually contiguous with the property. We're generally higher elevation, so we would be at eye level with the top of the cell tower should it be placed there. We want to wholeheartedly agree with the staff recommendation, and we see this potential rezoning as a very slippery slope, both for the future primarily because there are a number of other undeveloped tracts adjacent to this property. And so currently we have an area that is strictly residential, all R1 and R2. And if one parcel of R3 were to enter the area, that would make it potentially a lot more palatable or easy for this board and others in the future to consider more high intensity of use in surrounding properties, and we just don't want to see it go down that slope. The only other thing I will mention at this point is I too don't have particularly good service, even though I live very close to the crest of the ridge. It's not a factor of cell tower location that's responsible for the poor service in the area. There are a number of towers that are served by a number of different companies, and I investigated this with my provider, and they said they had acquired some towers from another company that they purchased that they would be reprogramming to give better service, but within a service radius there are no less than 5 towers in the area, and in fact I can see at least 5 of them from my house. So in terms of the need for cell service, it really is more of a technological problem than a location of a new cell tower. It might be economically beneficial or more convenient for a particular carrier to want to place a tower there rather than work out a contract agreement to put their service on another cell company's tower, which is already in the area. So that may be something you want to take into consideration. The only other thing I'll mention is R3. It hasn't been really pointed out very much, but R3 does permit rooming houses and vacation rentals, which I understand is going to be a topic of discussion later on in this meeting. I don't know how that relates to this particular request, but the idea that if that would create future problems by inability to manage the method for enforcement of licensing, et cetera, for vacation homes and rentals, that would be another problem with the R3 zoning in that vicinity. Thank you.
Thank you very much. Anyone else? I don't think we can allow a repeat.
I just want to submit something to you.
Okay,
I won't
that'll be
speak.
fine.
It's just the existing cell phone towers here and where we used to live in Bluffton, South Carolina.
Okay.
Just so you can see the differences in concentration.
Okay, thank
We'll
you.
have to keep these if you submit them.
Yes, that's fine.
Okay. Is there anyone else that would like to speak? Either for or against? Well, hearing none, I'll just go ahead and close the public comment portion of this process. Let me look at this just a second. What I could hear from listening today, as well as hearing from our staff and our county attorney's office, we've got hearing from the applicant as well. Of course, he would rather not have a rejection, but even if this was resubmitted to us and carved out strictly as a smaller tract and so forth and so on, and they reapplied, it looks like we'd be faced with a spot zoning issue for sure then. And I'm hearing Kurt advise us from a county standpoint that the deed restrictions simply that were proposed simply wouldn't be enough. So, and the only reason I said that is, one of the routes we could take is allow them to rescind their application and maybe reapply. But I think even with the reapplication, we're faced with both of those issues. So, having said that, does anyone else have some comments or opinions? Joe, do you have anything or related to this the application?
I think much of it's been said, but it is the responsibility of the board to consider all uses that would be allowed if the new zoning was approved. We just can't consider the intent, as we talked about. And the intent is not guaranteed. Ad infinitum, can be multiple owners on into the future. I'm very familiar with the area. I've been through it many times, and as the gentleman said in the letter, it is a beautiful, bucolic area. And I think approving this would be totally inconsistent with this beautiful valley and the backdrops and so on. And more particularly would have a property devaluation for the current residents of the area. Thank you, Mr. Chairman.
Thank you, Joe. Does anyone else have a comment?
Well, I think we could not deny it. We could put it off if the applicant wanted to do that, but I don't really see anywhere to go beyond that.
That's kind of what I was saying, Rod.
Well, you mentioned it, so I mean, if he wants to withdraw, then that's fine, rather than have a denial.
Okay.
I'll have one question just for Kurt. Due to the size of this property, the acreage, are we going to see anything that would force it to be considered large enough for, in the court system, or any kind of past verdicts that would say that a parcel that large would have to be considered in a different way?
I think that the parcel needs to be treated like every other parcel that you'd be considering. I think that this is it's ultimately, when you're rezoning a property, it's a legislative decision, and there's different factors that a court considers. It's more of a reasonableness as opposed to specific factors such as a permit that's being issued. So in terms of defensible, I think that there are arguments to support and there are arguments against. I think it's really a decision, that it's a legislative decision, and that you all are making a recommendation about.
Okay. Anyone else?
Debbie, how long have the Bonhams been there? Have they been there a long time?
I'm not sure how long, but quite a while.
Do you know? The question was, how long have the Bonhams owned the property? Do you have an idea?
I'm not certain.
Okay, thank you. Okay. Well, I hear a motion one way or another.
I move that we approve staff's recommendation.
Okay. I have a motion to approve the staff's recommendation.
And a statement about the consistency with the land use plan, please.
That it is consistent, or staff's recommendation is consistent with the land use plan.
I would probably go with the
not consistent.
The proposed amendment is not consistent with
It's not consistent with the existing land use plan, right? The requested map amendment would not be consistent with the Buckingham County Comprehensive Land Use Plan, and indicated that R3 is suitable for higher density use in mobile homes, and that the requested zoning would not be reasonable and would be detrimental to adjacent neighbors and surrounding community and not serve the public interest.
Okay. Do I have a second?
Second.
Okay, I think the applicant would like to say something.
Thank you, Mr. Chairman. Just to briefly say, you had mentioned possibly allowing us to, if you want me to step up?
Yes, please. I'm sorry. Should have asked you to come up.
Mr. Chairman, I would like to make a point. We're allowing this gentleman considerable amount of time, and if any other residents would like to say something, I think we owe that to them.
Okay. Noted.
Thank you, Mr. Chairman. You did make the point that if the applicant would like to continue this application, then you may consider that, although you didn't see the point. I would say that there may be other things that we haven't thought of today, and if we have a little bit of time, we could come back with something that could do that. So before you deny the application, I would ask that you give us the chance to do that. Second, I just want to point out a few things. My applicant lives on a 132-acre property, which for many of these residents here is part of the beauty of where they live, the view at which they live. It also costs a lot of money to maintain that. If you put a tower there, if that's the use, that's going to give them some income to possibly preserve that. And I can assure you that my client absolutely wants to do that. I'll remind you that multifamily is permitted by right in R2 or R3. I'm quite sure, after hearing all of you today, that that's something that they don't want.
Well, let me rather than open up the debate again, I've got one question.
Sure.
Do you want to rescind the application, or do you not want to rescind the application?
Well,
before we vote,
We have a motion on the table.
we have a
Right.
motion on the table.
Want to rescind their
And
application.
you can withdraw.
One or the
but
other.
It's one or the other.
Rescind and reapply.
at this point, I think if that's my option, I think we would prefer to rescind and reapply to be able to come back and address these concerns in a way that would appease the property owners and appease the commission.
Is that acceptable?
So just for the record, you are withdrawing.
Well, we'd like to ask for a continuance.
That would be up to the board.
That's
I think with a motion on the table, that's not an option.
I agree. I agree with Mr. Hughes. It needs to be a rescission and a reapplication.
I mean, I hate to do it, but I mean, in reality, we've gotten to the point now where we have an option, or we have a motion on the table.
The other thing, just to point out, is, you know, I don't think it's fair for you to waste your time. And, you know, I don't know, hearing what the staff has said and the community has said, I don't know if there's a viable option to put that tower up there. And I'm being honest. I mean, I don't think that you've got any votes up here right now. And I don't know, whatever, you know, I don't so much have a problem putting cell phone towers in R2, but right now the code doesn't allow that. And
I mean, it would require a change in code.
yeah, which
You would
is
have
not it, which
is a lengthy process.
Very lengthy process.
We don't do that easily.
And I'm not sure that, you know, I don't think it's something that we're willing to spend a bunch of time on. So, you know, I don't know where you can go from here, because I mean, I think it's.
I mean, as demand for that service grows, where else are you going to put it?
Well, I don't know, but we're not open for that debate right now.
I understand.
Is what
I
I'm
understand.
saying. And it's a simple question of whether you would rescind it or not rescind it, in my opinion, based on the fact we've got the motion on the table. I hate it, but that's where we had to get to this position, quite frankly. I hear what Bernie's saying. I would disagree slightly in one regard. I heard what you said. Maybe you can think of some other approach that may be more receptive to us. I don't know what it would be at this time, but you might be able to do that. So, but that's where we are, and I need to know one way or another so we can move on through the agenda.
Well, at this point, I don't have, again, the continuance would be what I would want, but I don't have the authority to rescind the application. So
Okay.
I'll have to ask you to go forward and just ask that you consider our.
Okay. Thank you very much.
Thank you.
Okay, we have a motion, a second, and we've had some discussion. So, is there any further discussion? Okay, the motion is to deny the applicant's request. Excuse me? Recommend denial. Yeah. All in favor signify by saying aye.
Aye.
All opposed, no. Okay, motion carries. Thank you. Appreciate your effort. Okay, the next item on our agenda is the discussion of zoning standards for rooming houses and vacation rentals. And I'll let some of the folks that are leaving leave if they'd like, or you can stay around too if you'd like.
Thank you.
Okay, you're welcome. Thank you. Thank you. Thank you. Okay, since our last meeting on June 20th, county legal staff had an opportunity to review the Senate bill that was passed at the last minute. I think it was early July when they adjourned from the General Assembly in Raleigh. And I've talked to staff a little bit. I haven't had a chance to talk to Michael, but we had asked Michael and staff to take a look at the impact of this decision in Raleigh and what limitations it put on us as we move forward with regulating the vacation rental industry. Kurt, could you, let's open up if you don't mind, could you address that for us a little bit?
In terms of the state statute really covers licensing.
Okay.
It doesn't really cover zoning. So from our legal standpoint, I think that the county has the legal authority to zone and designate which areas include rental vacation homes and which areas don't. I don't think that the state statute precludes that. So I think that what we're discussing or what the proposed amendments are, we would be okay moving forward, and we would not be preempted.
Okay, it's more a. Let me make sure I understand this. It's more a. It prevents us from granting licenses, receiving monies or permits or licenses, this type of thing. Basically, takes that piece off the table. Well, you weren't here at the last one, but we discussed that, and we've got two issues, I think. One
I
is
think that the state has set forth, and unfortunately, there have been so much state legislation regarding a whole lot of decisions. But I think from the main standpoint, what we were looking at is whether or not you can zone, and not really. I think a specific, you'd have to look at each licensing scheme on a case-by-case basis as to whether it conflicts, whether it conflicts with the state, whether the state statute would allow that. But I think for our purposes here today in terms of zoning, I think that that's clearly a function that the county has and that we haven't been preempted to do that.
Okay, thank you. Joe, did you have any further questions regarding that? I know you and I talked about this a little bit before the meeting. Does that kind of clear that up? Okay. Last week, on my behalf, Bernie and John Creighton met with a group called together by the Chamber of Commerce. And if you don't mind, Bernie, would you give us kind of a report? I wasn't there, and let us know what conclusions were drawn, if any.
Yeah, last week we met, and it was basically there were vacation rental folks that were there. There were hotel interests were represented, and also bed and breakfast. There was somebody that had a bed and breakfast, and there was, for lack of a better word, a very lively discussion over various options. The conclusion that I came up with was there was no agreement with the different interests on this. But I got some good input from all the different folks, but they really couldn't work out anything between them and come up with a consensus. Absence from this discussion, would have been just, the common lay person who, single-family homeowner or resident of Buncombe County, And
so there were no residents there.
Well, I was there, and I'm a resident. But and the people there were, but and I pointed that out to when our decision was made. We're not just going to take into account the stakeholders, but also the direct stakeholders, but also the residents themselves too, because that's what we're here to represent, the county itself.
So it's clear as mud. It remains clear as mud, right?
Yeah, I think that a lot of the discussion was over. Really was down to a minimum stay, and some of the hotel interest and the bed and breakfast wanted a longer stay versus a minimum stay. I think when we first visited this, we had no minimum stay. We kind of came out of it. I talked with staff afterwards, and what we had talked about was a 2-day minimum stay for being a vacation rental. I personally, they were pushing, some of the hotel interests were pushing for a 4-day minimum, and I thought that was too restrictive, just in the fact that it would eat up a whole week, and versus a 2 or 3 day minimum.
Okay. Well, what we've got before, thank you. Are you through?
No, I think so.
Thought you might be. Get you off the hook. Appreciate you going to the meeting on my behalf, too. What we've got before us today is language that we've looked at before, and the changes are in blue. And these changes reflect a 2-day minimum stay is what it says. Now, this language would still allow vacation rentals in those areas that are zoned R, LD, R1, and R2. Now, I've asked this question of John. John Creighton and I talked on the phone last week briefly. And I don't see it in here, and Kurt, you might be able to help me, but my concern regarding that, which I understand shouldn't be a concern, is that the POAs or HOAs, whatever they came up with in their covenants within their homeowners associations, should be able to trump what we come up with. In other words, it would supersede. In other words, the homeowner association said we do not allow vacation rentals, then that would trump this. I understand it's in there, or it's in some other language we've got. Is that true, or do you know?
Yes, even if we permitted let's say we permitted vacation rentals, if there was a private, a homeowner's covenant, restrictive covenants in a specific subdivision, those would trump. I think usually the issue is enforcement, where if you violate zoning, you get the zoning staff to come down, they can issue a notice of violation and pretty much deal with it on the spot. If it's a homeowners association, they're going to have to retain an attorney. It's going to be more of a private action. I think that's where you get some of the difficulties. They would be able to enforce a prohibited use that the county necessarily doesn't regulate.
Okay.
You've got several slices of the pie here. Within the potentially affected zoning areas, you've got neighborhoods that are not private.
Mm-hmm.
They're public neighborhoods where the streets or roads are maintained by the state. You have private subdivisions, more particularly on the slopes and ridge lines, because state-specified roads could not be built in these environments. So we have privately maintained roads. Now, within that, some subdivisions have homeowners associations, some don't.
Mm-hmm.
Some have road maintenance associations, some don't, because they can't come to an agreement on how to maintain the road. I personally know of some of these. For those subdivisions that have no, and then of course you've got some subdivisions that have restrictive covenants. So you can have a restrictive covenant subdivision with or without a road maintenance association, with or without a homeowners association. We have all of those different configurations. And then we have the public subdivisions, which are controlled by zoning only. Public subdivisions and residents of those subdivisions don't have a backup. They don't have a place to go. They have to depend on the county's zoning. Now, I'd like to go back to what the big crowd that left here said. I think there were some very important points that they made. Many of them, and the realtors know this, many of them moved to this area. Why? Because of the intrinsic values, because of the bucolic beauty of this area. Now let's take a young couple, for example, who has saved money, probably all the money they have, to put into a piece of property, either to buy the lot and build or to buy a home that's already there. So they go and they look at the zoning. And they say, okay, that's the zoning that I want. That's the culture. That's the neighborhood culture that I'm looking for. That zoning is going to provide me protection. Now, if someone wishes to live in a mixed area, then we have the zoning for that. And they can move into there and live accordingly. But if this young couple puts all that money into an area that has certain restrictions by the zoning passed by this county, and they go and invest all of this, and then we turn around and pull the rug out from under them, that's a sham. That's just not the way it should be. And we have thousands of citizens in this county who have made these kinds of decisions, be they people who are from here or be they people that are from elsewhere. They've made these decisions. If 25% of the properties in my subdivision are on the market. The property values have devalued 50% since the pop of the bubble. These properties have been on the market for 2 years or more. And now we're looking at the potential of violating the homogeneous nature of that neighborhood and putting the burden on the residents to carry this ruling if it passed. And all of these people have made decisions based on what the rules were at the time. And to change the rules would be a sham. If I want to live next to a vacation rental, I can choose to do so. If I don't want to live next to a vacation rental, and I chose the zoning that protected me from that, and now somebody comes along and says, well, sorry, your investment, don't worry about it. So there's a lot to consider here. There's a long-term impact. If I were a developer, and there are many developers out there sitting on spec homes and lots, they can't unload. And their subdivision is based on certain restrictive covenants. And I guarantee you, if you go and look at these restrictive covenants, you're not going to find vacation rentals as a part of the restrictive covenants. So I'm a little concerned that we have a movement by a few attempting to affect the investment and savings of many. I have a problem with that. Thank you, Mr. Chairman.
Thank you, Joe. Well put.
Joe, do you guys have restrictive covenants? Mm-hmm. I live in a subdivision too, and I think the average, the longest any house in our subdivision has been on the market has been 6 months, and our home values probably haven't dropped 10%. So I reckon, I'm pretty lucky on that part. We do have rentals in our subdivision. I don't think it's affected my property values. So I think that when somebody, and I've talked to neighbors that have moved in before, and they're not looking at the zoning of our neighborhood. They're looking at our covenances. That's what they're looking at, and the restrictions on it. And I think that it's not so much that we're taking a rule and we're bringing it, really an oversight when the zoning was done and trying to bring it up to what the reality is, out in the field. And we have zones in this county where there are large areas of R1 that are almost all vacation rentals, because of some of the retreats or camps that we have up here. And I want to, I think that we also need to kind of look at everybody. And this is the second time we've been through this. And the first time we went through this, we had 2 people that spoke against this ordinance. We had over 20 people speak for it. And we can't cave in to a vocal minority, which I think happens quite a bit in this area. I think we have to look at everybody's rights and what's best for the overall community, not just a few folks. So.
Well, if I may, Bernie, address the few folks thing, as it turned out, no citizens knew about this movement to start with. So we had a minority of vacation rental people who came forward with their legitimate request and worked it through the staff, and we ended up with it. But we had no citizens here, absolutely none. They were not a part of the process. There's been not an effort to make it public until the article came out in the newspaper. And now we have citizens involved. So I would submit that we are indeed addressing a proposal by a few that can affect many, and unfortunately many of the many still don't know what's going on.
Rod, did you have something?
Well, I was going to say, I think at the very least we ought to look at conditional use in the R1 and R2 districts.
Mm-hmm. Might be a good idea. Any others? Michelle?
Gosh, I wish I had known about that chamber meeting. I have lived in 3 areas of the mountains. I've lived in Silva, I've lived in Boone, I've lived here. And individual home vacation rentals have always been a part of the mountain culture. I mean, this is a long time and long process. We've had that. And Joe, I hear what you're saying about people who are buying for this reason and then it's changed. But there's been people who had land here 30 years ago that they could do anything on, and it suddenly changed. So I hear what you're saying, Joe, but I kind of, that zoning is a breathing, changing, supposed to be a breathing, changing process. So I think that there are many, many folks that I've known, especially where I live, that have had vacation rentals off and on in a family cottage. Maybe the son or daughter comes in and lives in that home for a while, and then they maybe put it back and rent it out again. This is not a new idea. Have we seen or will we see maybe an uptick in rentals due to the economy and the slow-moving real estate market? I would say, yeah, probably. But that's happened over the course of years in this mountain. That's not a new phenomenon. And I think that you would be surprised how many are out there now, and I feel like it would take away the uses of many more folks than it would just a few. And I would say, Joe, that if there are neighborhoods here that want to make sure to restrict those kinds of uses, and as you had stated, I know that sometimes hard to get people together to agree on a road, agreement or anything else. But that process is there. If they collectively get together, they can put covenants and restrictions together to prevent that. So, I think 2 days is a weekend stay. I know there are a lot of folks that have summer homes here and rent them out for certain weekend events. So I think 2 days for me is fine. And conditional use might not be a bad idea to hear some certain objections, but honestly, it's been permitted here for a long time. And my feeling is it should continue to be permitted. So,
You got any comments, Chief?
Good conversation.
Very good.
I agree with a lot of what's been said, particularly with regard to the fact that we're chasing a moving target. The fact of the matter is this zoning ordinance. There are a lot of folks who in this room remember a time when we didn't have these complexities, and these complexities we were warned when we implemented zoning of the fact that you cannot make everyone happy. That's just reality. You can't make everyone happy. And our job is to simply try and look at it from a perspective of what is best for the entire area and for the entire constituency. And so, I would also say that perhaps making a conditional use in R1 might be a reasonable step, but at the same time, I think the conversation we've had has got us basically what's here, and the 2 days I think is reasonable.
Okay, thank you. Josh, you have anything?
I agree that 2 days is reasonable, and I agree in large part with Michelle's comments. Vacation rentals were allowed for a long time before zoning was instituted, and I believe in a person's right to use their property in such a manner. I really do. But the fact is we do have zoning now, and we need to use it effectively. To Joe's point, there seems to be some concern among some folks that perhaps allowing a vacation rental in my neighborhood might bring down my home value. From my standpoint, and I've been involved in real estate for a long time, the worst thing of all for home values is inactivity. I would submit that any activity is better than no activity.
I'd like to add one more thing. I'm sorry, and I agree with that, and that's good. If the state had not had this particular ordinance, I had actually, and I think a lot of us had wanted to permit these, and I think that would have given more teeth to enforcement. At this point, we can't do that. And we just have no choice. We've been advised by the attorneys that we don't have the ability to do that. Now, that's not something that we can change, and I don't see another way to take an enforcement road. So that would have been an option I would have loved to have gone down and talked about here with the board in more detail, but it's just not something that's possible now. So.
Yeah, I was on board with Michelle regarding that as well. I thought we kind of had a course of action set out, and then we got derailed, so that is what it is. But I'll tell you what I think I'd like to do. I'd like to informally poll the board and regarding the language that's before us today. Then I'm going to poll you again, or maybe I don't need to do it twice, with regard to, at Rod's suggestion, applying a conditional use to either the R1 or the R2 piece. But what I'd like to do is get out of here with instructions to staff to republish this so we can go through the next public hearing process in the next 30 days that we're all looking forward to. So anyway, first question. If you don't mind, Rod, I'll start with you. How would you feel about moving forward and publishing the language as it is presented to us today? That is without the conditional use. But
well, I still stand for the conditional use.
Okay.
Yeah, the 2 day is fine.
Okay. Okay. Joe?
Well, it would be no surprise.
You can keep it short then, Joe. How about a no? And we'll go.
I oppose the whole initiative. Thank you.
I understand. Josh?
I support the conditional use in R1 and R2.
Okay. Barney?
I support it as written.
Okay. I would support it conditioned in R1 and R2.
I'd support it with conditions in R1. I'm not sure about R2, but I
Okay.
would probably go along with the mass.
And how about you, Michelle?
I would support it as written.
Okay.
I've got some concerns about making it conditional use. If it is conditional use, then where would that go? Would that go to the Board of Adjustment?
It would.
So what do you do with the ones that are grandfathered in? I mean, they wouldn't have to be affected by it?
If they were operating vacation rental prior to the adoption of the zoning ordinance, they would be grandfathered, and as long as they did not discontinue their use for 180 days continuously, they would be grandfathered from any type of permit or from requiring to have a conditional use permit, or if the use is not allowed in their zoning district, they'd still be allowed to operate their vacation rental.
180 days.
So there's a
is,
grandfather.
So, yeah,
you know,
it would- like you were saying.
if they hear it's summer rental and all they do is rent it, let's say halfway through the year, one time a year.
As I said, when you start talking about non-conforming uses, you're getting into a very case-specific,
Right.
it's a very fact-specific inquiry. Generally, that's what the rule is. Now, if it's a seasonal rental, we have to look at whatever the person, when it comes to our attention, we'd have to look at it on a case-by-case basis. But generally, if you have a non-conforming use, and as long as you continue your non-conforming use, you're allowed to keep it. That's generally.
Okay. What I determined from the poll, we've got two that clearly would approve the language as it's presented to us today, and the rest of us are either a no regarding the concept in its entirety, or would permit something, would agree to something if we change the language regarding conditional use, either on the R1 or R2 piece. So I think what we need to do next is determine, do we want to modify and publish the language allowing conditional use in the R1 area only, as Scott suggested, and I kind of like that too, or both R1, R2, and RLD? What I'm hearing is the pleasure of the board is we're in agreement with something like this. The 2-day piece is apparently okay with everybody. It's a matter of what we want to condition. Which areas do we want to permit conditional use?
Mr. Chairman, before you take that poll, I do want to point out there's 4 districts right now that don't allow them.
Okay,
And
please.
make sure that you've considered all of those in looking at this, and that's RLD, R1, R2, and BDM.
Beaver Dam.
Okay.
So if we did,
What about the Beaver Dam conditional
R1 and
use?
BDM.
Huh?
R1 and BDM.
Yeah. What Scott said, what if we go for conditional use in the BDM category as well as the R1 category?
In the what?
R1 and the BDM, the Beaver Dam community.
Oh,
Yeah,
Beaver Dam.
that would be conditional.
Why not include R2?
As conditional?
It's conditional. Mm-hmm.
I mean, my thought was just simply the density issue.
The what?
The density
The
issue.
density issue.
I mean, that may not be a good reason, but.
Okay, Rod, what do you think? We'll go do it again quickly. conditional use in the R1 and the Beaver Dam community? Those two?
Well, I still like the R1, R2, and the Beaver Dam.
Okay. Joe?
Joe's still a no.
I understand, Joe. I understand. Josh?
Is the reason it's not currently allowed in Beaver Dam is because of Beaver Dam's prior zoning did not allow the same?
That's correct.
Mhm.
The prior zoning
Correct.
only allowed single-family site-built.
Well, I'm certainly on board with conditional for R1 and R2. I'm a little on the fence about Beaver Dam. I'll include Beaver Dam as well.
Okay. But you're saying R1 and 2 and Beaver Dam?
That's correct.
All three, okay. Bernie?
I'm just afraid what's going to happen is we're going to overload the Board of Adjustment with a bunch of these. And,
Crazy.
you know, if we start...
And what will the Board of Adjustment use as criteria?
Mm-hmm.
Well, can I speak to that too? I doubt that there will be, I mean, maybe I don't know. Yeah, I imagine that people won't be just rushing in to try to put their homes up for vacation rentals. I imagine that most of the people affected probably already use their home as vacation rental.
That's what I was going to say. They'll be
Yeah,
grandfathered.
I doubt that everybody's just going to suddenly get into the vacation rental market. I mean, I could be wrong. There will be cases.
Well,
but I don't imagine
I think
a
the
flood of
economy is
applicants.
driving a lot of that too.
Yeah,
The
sure.
fact of the matter is, there are a lot of people who are in it right now who would not have been
That's
in it
right.
otherwise.
Right. But I agree. I think what you got on the table, the folks that are out there already are grandfathered anyway. And you would be, I don't see any surge, so to speak. I mean, there might be a few. What about you, Scotty?
I mean, my concern is simply the potential for overload. But I mean, I would go along with R1, R2, and Beaver Dam if that's
Okay.
the consensus of most of the rest.
Michelle? This is the last
Why are
time.
you laughing at me? I would say conditional Beaver Dam. I hadn't thought of that, and I know that community, that would be something long-term. I would have to feel better about grandfathering and how that process worked before I would agree to anything else conditional, period. Because I just don't think that's clear enough. And maybe there's some language you could put in to a definition that would help me feel better about that, but at this point, I just don't feel somebody could just come in and take away. Maybe they didn't rent it for a year. I mean, sometimes if they only open it up for 1 week, just like, let's say you have a homeowner who just wants to rent it for Christmas and Thanksgiving. And let's say that for some reason in 1 year they didn't rent it. Maybe they were renovating the property, or maybe, who knows. That is definitely going to take them out of that grandfather state, and I just don't agree with that. So I just can't vote for conditional for that sense. And that happens a lot. It happens a lot. That's all they'll rent it for is just holiday vacation. That's it.
Okay.
Is there a way you can take the grandfathered properties and make them permitted, like they've went through the conditional use, and then you're only listening to new ones?
Yeah, I think so. I didn't know whether Kurt was going to answer that or not, but we're back to grandfathering.
Okay.
Restate the question
Yeah,
quickly, if you don't mind.
You know, I think Michelle and I's concern is that, yeah, and I agree with what you're saying. Is there any way to take existing vacation rentals that are grandfathered and treat them like they've gone through the conditional use, that they're now permitted, and then any new applicants would have to go through the conditional use?
Theoretically, yes, but the problem is what are we going to do about the ones we don't? What are we going to do about the ones we don't know about and don't come forward until there's an enforcement issue? You got to be careful with blanket non-conform with it. It can be done, but it would have to be something that we'd have to look at, and I I don't think I'm prepared to give you a specific answer right now, but you can modify the non-conforming provisions for, let's say for vacation rentals, if that's something that people want to do. That is something we can look at.
Okay. Here's my concern is that we're, what, now 5 months into this discussion, and now all of a sudden we're starting to talk about conditional use and throwing that language in, and we've not really discussed that option before. And, you know, there may be ramifications that we haven't really thought out yet. And maybe I'm off base here, but I'm just, I mean, I'm just, am a little concerned about that.
Well, as Scott said earlier, there's no way in the world we're going to satisfy everybody.
No.
We've been here 5 or 6 months. We can be here 5 or 6 more months. And I'm not much interested now. I don't know about the rest of you. And we need to move on with this thing. We need to give it to the county commissioners. They can vote it up or down. And I'm sure they'll have a lobby full of people. I'm sure all those seats will be filled when that comes to vote. But what I heard in the last poll, I think there's 4 of us that would favor going forward with some language that has conditional uses attached to it, leaving everything else the same. And that was the purpose of the poll. You know, I know where Joe is, and I'm not in wholly disagreement with Joe either, to tell you the truth. I'm not real comfortable with this whole thing, to be honest with you. But we do need to move on. And as Scott, again, I'll reiterate, said, we're not going to satisfy everybody. A given, I think that there's 4 of us, that is Rod, Josh, I, and Scott, that would agree to go forward with conditional use provisions in the language. I would request that you do that. And that would be in the R1, R2, and the Beaver Dam areas.
And does that apply to the steep slope and protected ridge?
Well, one thing to keep in mind about Beaver Dam is that area is defined by the top of 2 ridge lines that come together, Elk Mountain and Town Mountain. So there are homes right on the very top of those ridge lines that are in the Beaver Dam district. A lot of people have a mentality of Beaver Dam being just the valley, the bottom of the valley, but it's not. It goes right on up to the top of the ridge lines.
So again, the question
homes
is,
are already there.
Does the conditional use apply to the steep slope and protected ridge? Or are those permitted?
Well, if the underlying district is conditional, then it would need to be
Then it would have to be
conditional in the
conditional.
overlay.
Right.
Can I just make sure I have this right? Permitted in RLD, conditional in R1 and R2, permitted in R3, NS, CS, and EMP, permitted in PS, conditional in Beaver Dam, and permitted in open use.
Correct.
Okay, I'm just checking.
Yeah.
Mr. Chairman, point of order, if I might.
Okay.
We haven't opened
I
for.
don't know whether what you're talking about as far as determining designations in the different districts is something separate and apart from the entire amendment itself. It's got an enormous amount of language that needs to be considered. If you're talking about this portion separately, that's one issue. If you're talking about it as part of adopting the entire language of the amendment that's been presented, I would like to have an opportunity to make a public statement about that, if that's what's going to happen.
Well, you can't today, except under public comment, when we come to that line item on the agenda. And if we move forward to this and it's published, of course, we'll go through the public comment process again.
I'm just asking about whether this is a question of just approving that one segment on the use table, or whether your vote that you're talking about taking now would apply to the entire amendment as it's presented to you by staff right now.
It would be all the language changes.
Yeah.
That's part of our process.
Yeah. Okay. Well, we won't take the vote until after we have the public hearing anyway. Yeah, which is another 30 days in our lives. Okay, I know not everybody's happy, but I would ask that the language be rewritten Jillian, as you went over with us, and republish so we can schedule a public comment period. Debbie, did you have something?
I did, as far as being conditional in those 3 districts. We can change that on the permitted use tables. Are you looking for us to write some conditions that would be applicable to that for the Board of Adjustment to hear?
Debbie, I took a look at what we have for vacation rental complexes, and if the planning board would just take a quick look at it, but it all works when you're talking about a single vacation rental that's under 9,000 square feet as opposed to one that's greater than 9,000 square feet or more than one. But if y'all would take a quick look at that and see if you're okay with what I have there.
You're talking the conditional use standards you have now?
Yeah, okay.
A through H. I'm not sure E applies, or the last part of E. I'm not sure that the last part of E applies. Vegetative buffer or fencing for parking. Typically, single-family homes a lot of times don't have separately designated parking areas. They have a garage or a...
That would count as their parking. One of their spaces. I can get rid of the stuff about the screened and vegetated buffer.
Yeah, I think that probably needs to go away.
So you're saying.
Okay.
Is that what you're saying?
I don't know how else you'd condition it.
Yeah, I know what.
I mean, other than what you've got written down, actually, for the purposes of the Board of Adjustment.
Yep.
And the Board of Adjustment could put a condition on a case, on a conditional use approval.
No, it's because it's so spread out.
Okay.
Do we get into conflict with the Senate bill if we put requirements even for conditional use that require approval of the fire marshal and
Well,
all
I
that?
think that, again, I would have to specifically look at, I think that's one of the things staff needs is a little guidance as to what specifically you want the conditional use standards to be.
I mean, by using conditional use standards, do we get into the point of where we're
I
actually
still
trying
think
to?
that I would look at the thing, I would compare what the conditional use standards are to what the state is. If there was a conflict, I would definitely point that out. But once again, most of the things of this thing are more zoning and developmental in nature. You're not asking them to get a license or pay any fee or anything like that. It's basically, you're taking a specific focus on, are they meeting sort of more intense zoning requirements for this use?
I would say look at section 1C in that bill. Take a look at that because I think it says that, I don't know, the language, we can't do something to require them to get permission from the county to lease or rent residential property. If conditional use is permission, then,
Well, it's.
I mean, you know, that's
I understand what you're
what my
saying, but
concern
yes.
is on that too, so.
Okay. Sounds to me like the language that we've got in subparagraphs A through H would not serve as the restrictions, the conditional restrictions, is modified. I think what Scott asked Jillian to do with the parking area, that was E, wasn't it? The last sentence, E, in E?
End of that sentence?
Yeah,
Okay.
yeah.
You're going to have conditional uses for vacation rentals, and then even have conditional use standards for vacation complexes.
Right.
Mm-hmm.
So you want them separate, so you wanted them, the,
I mean, I have no problem leaving it the way it is for vacation rental complexes.
okay.
But I
Correct.
think if you get into vacation rentals, then there's some of this that wouldn't apply.
Yeah, meaning what you suggested, I guess. It's the sentence you suggested.
That's right.
In other words, the vacation rental piece would be a reiteration of what you've got, with the exception of what Scott would like to see omitted. Yeah.
Let me try to understand this. So if we pass this as we're proposing to do with the conditional use, and if an applicant meets these conditions, then it'll get approved?
Yes.
And that's really their only requirement?
Yes, if you have specific requirements that say you have to do X, Y, and Z, as long as they do X, Y, and Z.
There are also conditional use standards.
And then, so they'd have to meet those permits, and then there are the conditional use standards. Also, we have a hybrid type of system where there's one where they look at specific factors, you meet the specific factors, but then there's things like, is there a public safety issue, or there, that citizens can come up and bring that up, and if the board finds one way or other, then they could theoretically deny the permit.
Okay. Okay, we set with regard to publishing language?
So you want us to publish it for a vote, or do you want to
hearing.
look at it one more time before you decide to do that?
I think it'd be a good idea to send it out to the board,
I can do that.
Yep.
and then,
Okay.
We can make email comments back to everybody if we've got
With the
comments.
idea of establishing a date for a public hearing?
Yeah.
Is it, we've kicked the can into September.
Email comments back to each other?
That's the earliest that we could vote on it.
I think that's right.
Does that raise any issues with?
Yeah, because we slid this,
I would just be careful with having a mass email chain where everybody's commenting to everybody else. I think that if you have specific comments to staff.
To give it to
they
staff,
stop
okay.
here, But I don't want to violate the open meetings law where
Yeah.
we're having
Yeah.
sort of a deliberation via email.
Right.
Yeah. Okay. Everybody understand that?
Mm-hmm.
Okay.
Could we review very quickly what we've done to all three tables?
What I have for the permitted use table for vacation rentals is permitted in RLD, conditional in R1 and R2, permitted in R3, NS, CS, EMP, PS, permitted in open use and conditional in Beaver Dam. And then for steep slope high elevation overlay and the protected ridge overlay, it would be the same as what I just said. They would all be exactly the same.
Both for steep slope and protected ridge.
Mm-hmm.
And you did have Beaver Dam as conditional under the first table.
And, correct.
Beaver Dam is conditional.
Yeah. Okay, so the plan is to send the language out to everyone, and everyone, don't hit reply to all, just reply to staff.
If you have any suggestions about the changes, you can send it back to staff, and then
Right, that type of thing.
we don't want to violate public, so
Okay.
don't have a discussion. If that makes sense.
Yes.
For the
Now, let me ask you something. Upon receiving, once you get it out, we get the comments back, how about going forward? Are we going to have to wait till our next meeting to publish this again? Or you could go ahead and publish it, couldn't you? So we could hear this the first meeting in September?
I think we could, once everybody's seen the language.
Okay.
You mean in August? You mean August?
Let's try to do that.
We could do it.
Okay.
See what the changes
All right.
are.
So basically what we need to do is respond before our next meeting, which is the first Monday in August, to you guys, so that it can be published and we'll have the hearing in September.
Or possibly even the second meeting in August.
Okay. 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 Let's move on. Not yet. No. I apologize, but we've got a public comment period, which is next, actually. But you're welcome to come up and talk. Next item on the agenda is public comment, and everyone gets 3 minutes. And please come up and state your name and where you're from, if you don't mind.
You need my name again. It's Liz Wiederhold.
Okay.
With my card.
I have your card.
Okay. With your permission, I'm a little embarrassed by doing this because you've gone through this whole discussion, but I wanted to throw a slight kink in. I wish I had done this ahead of time, but I really didn't think of the idea until a little later, or I would have contacted staff and tried to meet with them. I'd like to throw out, if it's not out of order, a proposed substitute regarding some of the other language, not so much the chart as there's some other language.
You got one? I got one. Okay.
I know y'all are sick of this, and actually, as Ms. Woods indicated, I actually am concerned that even with what I wrote, I am concerned that the conditional use isn't going to be permitted under this law. I'm not an attorney. I just read it 2, 3, 4 times, and the fact that it says that you the ordinance can't say they have to obtain permission, perhaps conditional use is altogether out, because that certainly seems like it's permission. But that's just an opinion. What I wear 3 hats, and I've talked to y'all about this issue several times with all the hats. Today I'm going to focus on my hat, because sometimes you just got to take care of yourself. My vacation rental property. I am in open use. I bought an open use, as Joe would say, bought an open use with a very specific goal in mind, and that is that you would leave me alone. I will not open a concrete plant, a chip mill. I will not run asphalt on my property. It is residential property, but I do operate vacation rentals. And the idea that I would have to come in for a conditional use permit to take my 3rd property adjacent to mine on a whole separate acre of property and turn it into a vacation rental is shocking to me. And that's what would happen, because the definition of the vacation rental complex would suck me in. I could operate a hotel on my property according to current permitting. I could operate a bed and breakfast, a family group home, but I could not have a 3rd vacation rental on my property without a conditional use permit, which I think is probably an unintended consequence. So I'd really like to ask that you look at the vacation rental complex, the larger group definitions, that they concur with the multifamily definitions. Right now you can have in the open use district up to 6 residences in a multifamily. It's 6 or more is a separate definition which requires a conditional use permit. But if I had built a building, a quadruplex or 5-plex, I wouldn't need a permit. I mean, I wouldn't need a conditional use permit. Seems rather silly. So.
Okay. Thank you. Appreciate it. Okey-dokey.
Mr. Chairman, thank you very much. Marcia Zerla, I'm a resident of Buncombe County. I want to talk to you a little bit, just quickly, a different approach to the way all of you are looking at this right now. You know my opinion. I've expressed at a couple of meetings, so you know how I feel. No reason to reiterate that. Mr. Kessel, by the way, I have been a member of a Board of Adjustment. It was my job to hear as many applications as came in. We stayed sometimes till 2 o'clock in the morning. That was the job I volunteered for, and so be it if that's the way it has to happen, depending on how this board votes. In any event, I don't think I have to remind anybody of the enormous amount of debate and unpleasantness that went on for, I don't know, a period of 2 years concerning the interpretation of the subdivision ordinance about permitted percentages of land disturbance and impervious surface. I mean, how long did that go back and forth, back and forth? There was no reason for that. Everybody knew that there had to be some permission, there had to be some disturbance, there had to be impervious surfaces. The question was the ordinance sufficiently written so that there could be only one interpretation? The answer to that was no. There weren't sufficient enough definitive provisions that would let you say, this is the way it is, period. You may not like it, but this is what the rules are. You've got exactly the same problems coming up with the way this amendment is written. It is going to be horrific. Let me point out a couple of things to you if you would take a look. The definition 78-581, rooming house, says 10 rental units. Doesn't tell you what a rental unit is. I have no idea. Is it a room? Is it 2 contiguous rooms, rented to one person, to 2 people? I don't know. It's confusing. If I don't know, you've got a problem. Vacation rental says no more than 2 single-family homes up to 9,000 square feet. Does that mean that each house by itself, rented to one party, is a vacation rental? If you can divide the house into segments, can you do that? And if each segment is rented, is each segment a vacation rental? I don't know. There's not a definitive enough definition in here. That is going to affect also how you do the computations in vacation rental complex. If I don't know whether the single house is the vacation rental or each segment that I can rent, if I can rent it, is a vacation rental, how do I come up with what is 10? Do I have to have 10 individual houses? Or I have houses that have 4 segments each? Does each house contain 4 residential vacation rental units? I don't know. The language is just not clear enough at this point. Look at the conditional use standards. It says dwelling unit, doesn't say vacation unit or rental unit. Subsection G says guest room. That's a new one. That's never been said anyplace. There are so many inconsistencies and so many difficulties that are there in the future. They're hanging out there just like there were in the subdivision ordinance. You have got to send this back to staff and have them pay close attention. You've already made the decision. It's clear. This board wants vacation rentals. Whether it's permitted or it's conditional doesn't matter. When you do that, yes, sir. Please look at the language of what you're going to do when you create that permitted use or conditional use. These are the rules that you're going to have to live by. If the rules are not readable and incontrovertible and without question as far as interpretation, you are going to be sitting here back for another 2 years with people coming in and out the door arguing about is it right or is it not right. Please don't do that.
Okay,
Please don't put the board through that.
Thank you. Next.
Hi, my name is John Moultrie. I'm rushing to get up here because, like a lot of you, I probably got to be somewhere else right now. A couple of things. I agree with the fact of we should need to protect the individual's rights on the property, why they came here, and why they've invested all their hard-earned money to be in this area, and the freedom that this area exists and why we're here. And that's why my family came here 200 years ago. But unfortunately, a lot of people have come the last few years, and they've tried to change the way the mountains were and the mountains are. And we're trying to accommodate people and trying to adjust to them. So, yeah, we've been impacted a great deal by zoning, some for good, some for bad, but definitely has cost us in the long run. And what has cost us the most is our choice of freedom on what we can do with our own property and the money we've lost as a result of that. The cottage industry has been around since the mountains, seems like to me. I know my family's been in it a long time. Thomas Wolfe, go back to that. In downtown Asheville, it is as much of this industry, tourism is, as the mountains and what we enjoy here. So this is nothing new. So I appreciate the comments, those of you said that. The other thing is that I have a unique situation to where my homeowners association will allow me to have a vacation rental, but you guys won't.
Mm-hmm.
Think about that one. Also, my homeowners association says I can rent my place out for Christmas and Thanksgiving so I can pay my property taxes. You guys say I can't. Think about that one. So you have the flip-flop situation. I have 3 houses up for sale now that are in vacation rental mode. I'm trying to sell them. I have not been able to sell them. They've been on the market, one for over a year now. I'm now faced with what can I do to try to offset some of the cost And all three of those, I'm looking at staging them so those look better, that I can sell, but also put them up for vacation rentals. But as a vacation rental, they'll sell better, we believe. But in the meantime, I can generate some cash during the holiday time, during October and July, and the other times. And so that's something. And the last point, so the 3 points is freedom that I really like to have more of. Second thing is the restrictions of the homeowners associations. And the third item is if you do want to go with this conditional use, it would be good, I volunteer myself and others, other people who might have some input into what that conditional use could be, because there's some unique things about our industry. And some of you may recall I'm in the hotel industry and the vacation rental industry and the long-term rental industry. So there are unique things about ours that we may have some insight into proposing some requirements, if we're allowed to by state law, on the conditional side. And I remainder of my time to anybody who wants it.
Thank you very much.
Thanks a lot.
Appreciate it. Thank you. Next.
Good morning.
Hi.
I'm Patricia Slattery. I don't have vacation rentals, nor do I ever plan on owning them, but I definitely agree with you, Michelle, and I agree with what John said. It's just another step in handcuffing people from their freedoms that you're entitled to, and that I am completely opposed to. But I do have questions with regard to the districting. Someone like myself, who clearly by my accent, I'm not from the mountains, nor did I buy in a gated community either. I bought, and I live in a little farm area out toward Arden and Cane Creek, and I love it out there. And I would have no problem with anyone renting a property for vacation purposes around me. Because I do feel that there's laws in place that if it were to get a little rowdy, we do have sheriffs that we could call to keep things in control. But I do have questions in terms of RLD, R1, R2. Where does someone like me find those zoning maps so I know where we're talking about? So when these conversations come up, I know what to be looking for.
The zoning maps are available online through the GIS website.
Would you be so kind as to give that to me, please?
If you go to buncombecounty.org
Mhm.
and then follow the links to GIS, I'm not sure exactly what it is, but you can call the planning department or the GIS department and they'll help you find it.
Okay, great.
It's under the real property section.
Thank you.
The GIS is also on the home page.
Right.
On the left side, the sidebar down the left side, you'll see a link for GIS.
Great.
Then you click on the agreement, then it'll take you in there. Then you have to figure out how to work the different overlays.
Yeah, okay.
No.
That's where it gets a little tricky, isn't it? And one more question. When we're talking about conditions and conditional use, what are we exactly talking about? Has it been defined yet what these conditional uses are?
Yes, within the zoning ordinance, there are certain uses that are called conditional uses, and they require an application and a public hearing before the Board of Adjustment. It's a quasi-judicial board. They look at the standards of a conditional use permit within the zoning ordinance, and then some specific conditional uses have additional standards, and they look at those and then make a decision based on whether or not they feel that they meet those conditional use standards or not.
And one would find that also in this GIS?
It's in the zoning ordinance.
If you look at Code Section 78677, subsection G would be the section for just general conditional zoning uses.
That kind of gets so convoluted, don't you think?
Ma'am?
It's so not straightforward.
We have planners available. There's always a planner available, so if you'd like to come down to the planning department, we can show you the GIS website and we can go through the
I'm just talking for
zone.
general people that are interested in the community, that everybody doesn't have the time to come and do that. That's my time, I guess, right?
Yeah, but I would suggest, since most of yours are questions, this type of thing, going down to see staff possibly down at their office, which is right literally behind us, so to speak. You go out and take a left and a left, and it's about a couple of 100 feet down the hill.
Okay, great. Thank
Okay?
you very much.
Thank you very
for your
much.
help.
Next.
Hi, my name is Zoe Berger, and I am a resident of Buncombe County. I live at 299 Merrill's Chase Road, and I've lived there for 14 years. We've raised our children there, and it's a 5,000 square foot home on 7 acres. We live on top of a mountain. We are zoned RLD. We bought the property 14 years ago because there were not many deed restrictions. We could have made it a vacation rental at that time, but that was not something that we were interested in. We wanted to raise our children. Our children are now moving out of the house. We have this huge house on top of the mountain that we are ready to move off of. I recently looked into renting our house as a vacation rental because several people that we know throughout different countries, throughout the U.S., have been to our home and would love to rent it as a vacation rental. Well, I just found out that the zoning changed this past October, and I can't rent it out as a vacation rental. The house has been on the market for 3 years. It has not sold. We are ready to move off and be closer into town where our daughter will be going to Asheville High School. We do not have a homeowners association. We only have a road maintenance agreement. We are not forbidden from making it into a vacation rental, and there are people on the mountain that do not oppose of it. They're okay with it. People that we know or that we don't know that would come to rent our house, it's a 6-bedroom, 4-bath house, have money. They want to come here. They want the experience of not going downtown and renting a hotel, but being in a home with their family, cooking, having views, having space, and they're going to spend money in this community. They're going to give back to the economy. And if you don't allow the vacation rentals for these type of homes, you're going to lose those people because they're not going to be able to come here because that's what they're looking for. Again, we've owned our property and paid taxes for 14 years. This is our property. And Joe, before this passed in October, we were allowed to do anything we wanted. Now we can't. Now it's been flipped for us. We looked into property that did not have many deed restrictions. Now all of a sudden we have this restriction. I think you need to vote back to the way that it was. I think that's only fair, especially with this economy, and people probably are going to, who can't sell their home, are going to look into making these homes vacation rentals so that they don't lose their hat, so to speak.
Mm-hmm.
That's all I have to say. Thank you for your time.
Thank you. Next.
Good morning, Al Gumpert, resident of Buncombe County. One question, I'm not sure why you left RLD out of your consideration to go with R1, R2, and Beaver Dam as a possible conditional use. But that aside, this issue of property rights cuts two ways. Do I not have the right to enjoy my home without a business next door? I hear that most renters are not a problem. But I also hear of instances where people rent a house, they bus in other people to have a reception or a party, and it turns into a zoo. We've had experience in our own neighborhood with someone renting a house out indiscriminately, causing problems for the neighbors. So I think as residents in a R1 area, we have property rights too, and what you're suggesting is that you can take them away. And I think we will argue that point. Thank you very much.
Thank you, Al.
Yeah.
Anyone else?
Hi there. I'm Barbara Melton, Coalition of Asheville Neighborhoods, and Rod and I have been on opposite sides of the fence on a lot of cases with the city. But I want to thank you, Rod, for bringing up conditional use for this, because let me assure you, I served on a committee for 3 years with the city of Asheville trying to wrestle this problem. And you're right, you need neighborhood representation, because the neighborhoods are the ones that are affected. Yes, I have rights. If you're going to make these to be okay in all these districts, that is your prerogative. But may I say you're opening up a can of worms, because I represent 70 different neighborhoods. You talk about problems with these rentals. Not all the time. Some folks take care of property just like it was their own. But you always have the folks who say, hey, I'm renting this, what I care. And it's the people around them who have to become the police. And lots of luck with calling the sheriff's department or the police department unless they're out shooting guns in the neighborhood at 2 o'clock in the morning, because if it's just a bunch of cars and noise and stuff, they're not going to come check that. They don't have time. So you've got to look at your costs for enforcement and be darn sure you can enforce what you pass. But I do thank you, Rod, for coming up with conditional. I hope the state law will allow it in the R1, R2, and Beaver Dam areas. Our neighborhood associations will certainly appreciate it, because we're obviously pay Buncombe County taxes too. I live in Hall Creek. We've got rentals all around us. But you better believe those that we are aware of, we keep an eye on. But it, again, makes us the police. But thank you for the time you've put in on this. Please be very careful with it. And I agree with the lady as far as your definitions. I sat on the Planning and Zoning Commission and chaired it for 8 years for the city of Asheville. May I assure you that if you don't have those definitions down, if or but can break you, can't they, Rob? Thank you.
Thank you very much. Anyone else?
Bob Gans. I live in Fairview. I came here with a clean sheet of paper. These are kind of some of the thoughts I have in response to some of the discussion that's been held. First of all, I'd like to tell you just one thing about myself, and that is some of you may think of me as a crotchety old resident who just doesn't want to be bothered by some of this garbage. But I have a long history of business experience, having been in industry for 36 years. Currently, I teach courses, business courses at a major university. I'm the president-elect of SCORE. And for those of you who don't know, we counsel and try to help small businesses who both have problems or are trying to get into business. I also am working or starting to work with the Chamber to try to work with them in attracting new businesses. So I'm certainly not anti-business. And I do have the perspective of both business interest as well as homeowner interest. Mostly like what I want to do in the probably 2 minutes I have left is react or respond to some of the comments that have been made. I understand the point you made about anybody could do anything around here for a long time. Well, I think the folks that decided that we needed some kind of control over development when they first tried it in 2007, then in 2009 had to pass it again, and I guess in 2010 passed the steep slope ordinance, I think they had it right. I think their objective, in addition to protecting the values of these properties, they saw that being done by managing, controlling is a word I don't like, but managing the growth and development. And in fact, one of the things they did was they said businesses aren't compatible with residential areas. That's why they precluded things like vacation rentals, which all of the realtors in the last meetings I've sat in on admitted were basically businesses, unsupervised businesses at that. And I think that was the right answer, and I think that's what will happen. I would put ditto to just about everything my friend Joe said, or Al said, I'm sorry. And especially the point he made about why are you excluding RLD? I obviously don't want conditional. I want it banned, period. I want the zoning not changed. But RLD, I mean, we might be, whoops. That was for me, huh?
That was for you.
Okay.
Go ahead
Well,
and wrap it up, though, please.
I hope, I'm in an RLD. We have 2-acre lots. We're some of the most beautiful property in the area. Why you're excluding this, I simply don't understand, and I hope you will share with us the logic for excluding RLDs, but making conditional uses out of R1, R2, and Beaver Dam.
Okay, thank you, Mr. Gans. Is there anyone else?
My name is Mike Clotfelter. I am a landlord, real estate investor, and also president of the Carolina Real Estate Investors Association. I am for the change in the ordinance. I'm not for the conditional use. I think that's a bad thing. I think we're going to get in trouble with that. But some of the comments I've heard, true, it may be a business. But in most cases, there's always an exception, but in most cases, I don't think you'll even know that the business exists there. Most of the clientele, from what I've done in research, is it's an older clientele. They're well-heeled, well-off, and well-educated. I would like to relate a story if I've got enough time to do it. I've got an acquaintance that is from Illinois that has been coming here and renting vacation rentals for the past 3 or 4 years, and he gets different areas every time he comes because he's researching where he wants to live, where he wants to move here. And this past year, he did buy a house. So I think it's beneficial in that area. It's also economical. It will be an economical boon to the economy. So please, I hope you support it. Thank you.
Thank you, sir. Is there anyone else? Well, it appears there's not. So we'll close the public comment section of our agenda. Do I have a motion to adjourn?
So moved. Second.
In unison, we have Holmes and Hutchins. And either. Well, that's a close call. Give it to Josh's first and Rod is second, I guess. Okay, all in favor say aye.
Aye.
Okay. See you August 1st, I believe it is.